Hi, Andrew Pfeiffer here from Pfeiffer Login in Akron, Ohio. I've been continuing to film videos on the probate process in Ohio. This is an area of my practice that I just get so many questions in. Probate, trust administrations, the whole process around someone passing away, asset transfer and valuation, debt payment, who is involved, how does this work? Today we're going to take a look at fiduciaries and what is the role of a fiduciary in a full administration in Ohio. So the first thing to understand is a fiduciary relationship is a special type of relationship that you'll hear talked about in the law a lot. It involves a principal or a number of principals and an agent. And that agent is the fiduciary. And the fiduciary has these common fiduciary powers, right? The duty of loyalty, the duty to act in good faith. It means they're going to act in the best interest of the principals, which in an estate context is often heirs, beneficiaries, legatees. And so our fiduciary can take a couple of different titles, and I know it can be a little confusing, but some of this is based on, is there a will or is there no will? So if there's a will that names a person to be in the fiduciary role, that person's often going to be called an executor, or in the case of a woman, an executrix, and the same thing for an administrator or administratrix if there is no will. So what are the primary roles that this fiduciary, this person who's now been appointed by the court, has to do once that they're appointed? The three primary roles that come to mind are collection of assets, payment of debts, and ultimately distributions out to heirs, legatees, or devisees. And so what we see is a court appoints a fiduciary, and then a timeline starts to run that I've talked through in my other videos. And in that process, the first thing that's going to happen for the fiduciary is letters of authority. These are letters of administration in the case of no will, or these are letters testamentary in the case of a will, but they're commonly called letters of authority. And these are the letters that allow a fiduciary who's been appointed to begin to take control and manage the decedent's assets. So opening up an estate account in the decedent's estate, taking assets from other bank accounts, selling real estate, signing a listing agreement, getting a business valuated, liquidating motor vehicles if they need to be liquidated. All these things, taking account of debts that are coming in that need to be handled. All of these things that happen are guided by the fiduciary, usually working with a probate attorney and paralegal staff like mine that handles probate administrations regularly. But ultimately, what I want you to see is the fiduciary is an agent of the estate. They have a duty to act in the best interest of the beneficiaries. They need to take control of assets. They need to protect assets. They need to make sure assets are properly insured. They need to look at the ways that they can take the assets that are coming in at the beginning and ultimately get them to the end where they can be distributed out to the heirs, the devisees, or the legatees, depending on the type of administration that we're working. Thanks so much for learning a little bit more about fiduciary roles and duties in Ohio. I hope you'll reach out to me directly if you have specific questions, or if you've been named a fiduciary in an estate and you want to talk through what's coming at you and what the next steps look like. Thank you.